In Wisconsin, an employer must pay into the Unemployment Insurance Trust Fund for every worker classified as an employee. When a worker classification dispute arises between unemployment insurance officials and an employer, the matter may require a hearing to determine whether the employer has misclassified the employee. If the Department of Workforce Development determines that an employer has misclassified an employee, it will notify the employer of its UI tax liability for that employee, along with any associated interest and penalties. The employer may file an appeal. The department will acknowledge the appeal in writing, assign a department attorney to defend its determination, and contact the employer or its representative with the hearing date, time, and location.
Hello, this is Marie.
After receiving the appeal acknowledgement, employers are encouraged to contact the department attorney to discuss the possibility of resolving the matter without going to a formal appeal hearing. At the appeal hearing, an administrative law judge will hear the case. Hearings may take place in person or over the phone, and all proceedings are audio recorded, with the recording kept by the department for future reference by all parties involved.
I'm going to begin with.
In the event you're involved in a worker classification hearing, it's critical for you to prepare yourself and your case. First, familiarize yourself with the two-part worker classification test and bring evidence that directly supports your decision to classify the worker in question as an independent contractor. Second, gather the facts that support your case and be prepared for any questions that may arise during your hearing. Read your hearing notice carefully. It contains important instructions on how to handle various documents and evidence that can strengthen your case. Typically, the department will present its case first, based on written documents, an auditor's testimony, or testimony of other witnesses.
Your Honor, I guess I'm just...
After the department attorney has presented the state's case, it's the employer's turn to prove that any workers at issue are not employees, but independent contractors.
Relocated and we decided to...
Please raise your right hand.
As the employer, you may use direct testimony from witnesses, work documents, or other exhibits that pertain to the case.
What kind of review or close attention do you give to...
Both parties may cross-examine each other's witnesses, and the administrative law judge may also ask questions. If witnesses are not available to appear in person, they may testify by telephone.
Expect to receive that within about 30 days. My decision
Once
will
all
tell you what to
testimony and
do.
evidence has been presented, the administrative law judge will issue a written decision called an appeal tribunal decision. The employer has the right to appeal the decision to the Labor and Industry Review Commission. If you're an employer appealing an initial determination regarding employee classification, it is critical that you prepare yourself for the upcoming hearing. To learn more about the Department of Workforce Development's worker classification law, visit www.dwd.wisconsin.gov/worker_classification.